do you call whoever we got back there for 1:30 and we'll move forward that way. And we already took care of Michael Lee, is that right? Oh, I'm sorry. Hold on. We'll get to you in just a second. Who is this then? Livingston?
Yes, Your Honor. This is Daniel Livingston. Your Honor, we had put Mr. Livingston over from last week to see if we could get the restitution amount that is being sought. Mr. Gomez informed me this morning that he was not able to do that. So if we could just continue Mr. Livingston to the 512 docket, I believe he's already on that docket.
All right. So we waived formalities, enter a not guilty plea, and leave it on the docket.
Yes, Your Honor.
Okay, very good.
All right. All right. Good luck.
Who's next? One, Mr. Lee? Come on, Mr. Lee, while we're waiting for the other folks. That's you, Mr. Lee's yours, Mr. McKinney, is that right?
Yes.
Michael Lee? Come on down, sir. Come on down. DWLS with prior, 25 CF 600.
Michael Lee Young.
I'm sorry, Michael Lee Young. Yes, I apologize, Mr. McKinney.
That's okay. Judge, may we pass him just a moment? I'd like to speak to him in the hallway and then call him right back in just a minute.
Absolutely. Sure enough.
It's number 14.
Yep.
Young.
Amanda McFadden.
Yep.
McFadden.
A couple weeks ago. It's less than time ago. Okay. Your Honor, I was just talking to Ms. McFadden. Just recently, I was, like 20 minutes ago, advised of something medically related to Ms. McFadden. We were trying to get this resolved today. There is a 3-count information. We will waive the formal reading into a not guilty plea. This case was originally put on the the July 14th docket. Yes. Okay. Your Honor, if we could just pass Ms. McFadden briefly, we're going to write up a plea agreement to get this resolved today.
Yes, sir.
All right.
Get it resolved today.
You're coming back out. I just got to get the plea agreement changed.
Nathan? Yep, come on.
Your Honor, this is Ms. Sharice Naismith. She is going to be signing a plea agreement here to resolve this. At this time, Ms. Naismith is going to acknowledge receipt of a 2-count information. Count 1, today is 4/20. She's going to be entering a plea to the lesser included offense of felony petty theft. She'll be pleading as charged on count 2. The agreed upon disposition on count 1 is that Ms. Naismith will be placed on 2 years of probation. She will perform 24 hours of community service as a condition. She will have a shoplifters awareness class. She will pay $102.89 restitution to Hobby Lobby. She will do a mental health evaluation and any recommended follow-up treatment. She will be assessed $610 in court costs, $150 in public defender fees. There would be a withhold of adjudication here. Just so probation is aware, she is going to be in custody on a misdemeanor violation case until probably May 7th. So she has been instructed to report immediately upon her release to the probation office. It's just not going to be too late. Okay. May I approach, Your Honor?
Granted.
Did you get the score sheet amended?
Can we have the statute number, please?
Yes, Your Honor. It's on the plea agreement. It's 812.014 subsection 2 subsection D. And I apologize, count 2 is a misdemeanor. That's going to be credit for time served.
That's
And
gonna
Mr.
take,
Gomez is going to be amending the score sheet.
You got it?
it might take me a little bit to amend the score sheet, Judge. I'll make sure I show Mr. Kleins when I'm done.
All right. So just to be clear, and this is not about you. This is not about you.
Sorry. Yes.
Plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
I
Our court will find the plea to be freely and voluntarily entered into and will accept the plea. And that on count 2, it's time served, Madam Clerk.
am. And time served will be
And don't come back and do it.
is it time?
No, that means you've finished all sentence that you have on count
So
2.
will I be released?
You should be released as soon as this is processed.
Well, she should be released once she gets the misdemeanor violations resolved.
Oh, so that, she has the other case that she
That's
has to.
correct. She has some pending misdemeanors right now. The state's offer is 60 days. I expect that to be pled probably on May 7th.
Okay.
So,
So that's different than this case, different completely. Now, because that's a theft, she'll still need to get her prints, Charles, right? Since it's a theft, even though it's a withhold? Yeah, I think she gets printed on a theft. Okay, so you need to step this way and get your fingerprints.
thanks, I appreciate it.
Any objections to score sheets, Mr. Kleins?
No, Your Honor. I did review it. Yep. Your Honor, this is Ms. McFadden, and just so the record's clear, I sincerely appreciate what the state's current offer is. It's based on the information I just received. At this time, Ms. McFadden would be entering a no contest plea as charged. The agreed upon disposition is that she will be sentenced to credit for time served. She would be assessed $615 in court costs, $150 in public defender fees. She has previously been adjudicated. May I approach?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, you heard what Mr. Klein said, and you signed the written plea form.
Yes, sir.
How old are you?
I'm 35.
And how much school do you have?
11th grade.
You able to read and understand this plea form?
Yes, sir.
And did you do that before you signed it? I know it all happened real quick here, but it sounds like you talked to Mr. Kleins about this before.
Yeah, he's seen me 3 times. He's great, but he's leaving us. So yes, I just say.
He's not going far.
Oh, okay.
Too far for me, though, but I'm just saying. I still got that writ down. I haven't issued it yet. All right, just kidding. All right, so you understand, and it's what you read in the plea form, what Mr. Kleins announced to me just now.
Yes, sir.
All right, so you understand that you're pleading no contest to the announced charges.
Yes.
And that says to me, you believe the state could prove your guilt and you're not going to contest that.
I understand.
And you're waiving your right to a trial by jury.
Correct.
And you're going to be adjudicated guilty of these charges, sentenced to time served, and you have the fees and costs that were announced that you'll have to pay.
How long can I get, Your Honor?
Well, how much time do you think you need?
4 months at least, because I'm on disability. So
You think you-
I need to pay rent and stuff.
I would request 6 months, Your Honor, given that.
Yeah, because you've got the 615 plus 150 and plus whatever else you got outstanding. Do you think it's real? And once again, my goal is to be sure to give you enough room that you'll have the opportunity to pay it, right?
Look,
That's my,
6 months is good, actually.
Okay.
And then if I do come here and say I can't anymore
Yes, ma'am, as long as you're making payments, I'll give you more time, but if you don't even bother making payments, don't ask for more time.
Yes, sir.
Okay, so 6 months to pay?
Yes, thank you.
Okay, all right. And now with that, has Mr. Klein's answered all your questions?
Yes, sir.
You satisfied with what he's done for you?
Yes.
I'll find the police freely and voluntarily entered into, and I'll accept the plea. Thank you.
All right.
This will be Levi Pierce. This way.
Judge, it's Mr. Levi Pierce in 25 CF 580. Receiving the two-count information will be entered not guilty, waive formal readings, and request to be kept on that July 14th pretrial docket, Judge.
So ordered.
Thank you.
Pruitt.
All right, Mr. Pruitt, you're here today without a lawyer. You don't want a lawyer to help you?
I thought I had one on my case.
He has several open misdemeanor cases. I'm not sure if he's been appointed in the felony.
All right, Madam Clerk reports that he has been appointed the public defender in his misdemeanor cases. The public defender will be appointed to represent him in 25 CF 624.
Judge, being appointed, we do see the one-count information, be entered not guilty, waive formal reading, and request to be kept on that 7/14 pretrial docket, Judge.
So ordered.
Thank you. Not yet.
Next we have Mr. Moore, Devin Moore, but he's referring to Mr. Notes. I don't see it here.
Mr. Nopes is currently on Zoom at 2:30.
Well, but we need to finish our, that's 2:30, right?
Correct, Your Honor.
Yes, sir.
So we've got, show Anthony Brown left and Michael Young and Corey Pelnitz on the 1:30 docket, and then we'll get to the 2:30.
Judge, if we can address Mr. Corey, last name Pelnitz, in 25 CF 575.
Yes, sir.
Judge, I did file a waiver, will be entering not guilty, and request to be kept on I believe that's the 512 docket.
All right, so ordered.
Thank you, Judge.
Thank you.
Anthony Brown. It's Mr. Klein's, right?
to step outside.
Okay.
Is Brown here?
He's got a show. He was transferred from Division One, Virginia, still on case.
Okay.
There's no information.
There's no information?
Which is this? Who is this?
Brown?
Anthony Brown.
He got transferred.
Oh.
into-
So actually, I had talked about this with Mr. Cochran earlier. Yesterday, that was transferred into our division. It does not look to me like there's an information filed in the newest case. And he's not on the transport list. He is in custody.
All right, so we'll move to the next date. May
Is this-
16th.
Is there an information?
No, I didn't even know she's transferred.
Right. So he has two cases. One of them, he's already actually been evaluated for competency and found competent. That case has this I think this is that information. This morning I looked up benchmark. In the newest case, there is no information. So I really don't know how the court wants to handle that.
Well, we'll reset it for the next plea day,
I believe that would be,
5:15.
Madam Clerk, is his older case, is that already on the May 12th docket?
They're both set for me.
Okay.
I mean, I'll make sure, I'll make the info.
And we'll just do, but we'll set it on the 15th so we have safety valve, okay?
Okay.
That's all right.
Docket management. Okay, Michael Lee Young.
Judge, you reviewing a plea agreement? You have that conflict? You good? Yes. You sure? Stand right here, okay? Date it. If you need more time, you can have more time.
I just, yeah, I didn't get. That's fine.
You sure? Judge, this is set for arraignment today in 25 CF, 600 for a one-count information. However, we've reached an agreement with the state. That agreement calls for a plea to a lesser included offense of driving while license suspended or revoked, a first-degree misdemeanor. Madam Clerk, what we're talking about is 322-34, sub 2, sub B1, which would be a first degree. 11 months, 29 days JCS probation with special conditions that include 30 days in the Okaloosa County Jail with credit for time served, and that may be served on weekends or 2-day periods. I've explained that to Mr. Young. $270 in court cost, $150 cost of defense. The probation is to automatically terminate upon completion of the jail condition. He would be adjudicated guilty of a misdemeanor. May I approach?
Granted. All right, raise your right hand for me, please. Mr. Young, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, yes.
Okay? Now, you understand you're pleading no contest to the lesser included charge. Is that right?
That's fine. Yeah.
All right. And that says to me that you believe the state could prove your guilt to that charge and you're not going to contest that. Is that right?
Yes. I mean, I'm not driving. I mean, I don't have a vehicle anymore.
Okay. But it's as to this charge, you understand, but that's what your pleading no contest says. You understand by pleading this, making this plea, you're waiving your right to a trial by jury where the state would have to prove that. And you'll be adjudicated guilty, be on 12 months of probation with 30 days in the county jail to be served on weekends, which we would define the weekend as you got to report at 7 o'clock on Friday night, and you get out at 7 o'clock on Sunday evening. Is that all right?
That's fine.
And when are you going to start? When's the first weekend?
Probably, could I get 2 weeks? At least, right now?
Well,
Because I'm transitioning from one place to another.
sure.
Yeah.
Well, let's just, tell me a specific
Yeah.
date, because I get confused with how many weeks it is. Tell me the date, first Friday you're going to report.
All right, say the 2nd of May.
Well, that's next week.
That's next, you say May 9th?
That's fine. Yeah. That's fine.
May 9th?
Yeah.
So first weekend would be May the 9th, right?
That's fine.
And you got to do every weekend thereafter until you get your 30 days.
Yeah,
Is that agreeable?
that's fine.
All right, and as soon as you finish your 30 days and you pay off your fees and costs, you can terminate. Is that what your agreement is? And Mr. McKinney answered all your questions about the plea and how it affects you.
Yeah,
Are you satisfied with how he's represented you?
yeah.
Okay, all right. Now, you're going to have to go and report to JCS as soon as you can. Now, it's kind of late this afternoon, but you still got to get there to report to them and let them know what's going on so they can set you up, okay?
All right.
Any questions? Any questions?
That's fine.
Okay, all right. Court will find the plea to be freely and voluntarily entered into and accept the plea. All right. I guess Mr. Wade. You ready with Mr. Vo? All right. Now, I see the state did file a response to the motion to dismiss, so where does that leave us?
Well, I think on the motion to dismiss on that, I'm clear with the state that I do think that that's basically a legal issue for the court to decide. I think that it's there in front of the court on both the defense side and the state side at this point. You understand, Kevin, what the court's asking is, with hearing, we're set for a hearing. The state did file a written response to the motion, I think yesterday or the day before. I haven't had a chance to give it to you, and obviously they contradict what we're saying, and there are arguments contained in that. But our argument is also set out in the written motion which I filed. I don't see the need for there to be additional testimony or necessary argument, but other than what's in writing. Do you agree with that?
I see.
Well, it's not going to be arguing the response. This is the state's response on the motion to dismiss. Mr. Vale, Your Honor, that he's in agreement with me that I think that it's proper for the court to consider that particular motion upon the written submissions of both the defense and the state. Of course, and I explained to Mr. Vale that we're in no way conceding the correctness of the state's argument, and I'm assuming that the state is not conceding to the correctness of ours, and it's a legal decision for the court to make.
All right, and I will take it under advisement and render a written response.
Thank you. And Judge, if I may, I do have the CD of the calls. There's 14 calls on there.